Good afternoon, everybody. Give me 1 second. I'm just going to close the door over here so nobody bothers us during our lunch conversation. Oh, somebody's going to do it for me. Great. Well, good afternoon, everybody. Thank you for joining me today to talk about your retirement accounts. So my name is Whitney O'Reilly. I'm an attorney here at Cohen Seglias. I'm an estate attorney, so I do things like estate planning documents. Draft your will, your power of attorney documents, your living will, and then after you pass away or a family member passes away, I help a family through the probate process, the estate administration, filing death tax returns, and working with business succession planning. So I've been doing this for about a decade now, and I've been working in retirement accounts, in estate administrations, and in estate planning client meetings for well over a decade. And this is something that's really, really important because hopefully everybody on this telephone call has a retirement account. And we want to make sure that we get as much money as we possibly can from that retirement account. Or when we pass away, we want as much to transfer to our beneficiaries as possible. So let's get started. This is actually my first webinar, so hang in there with me. If there's any glitches or you can't hear me or you can't see me or I'm making funny faces, it's just because this is the first time I'm doing it. But I hope this makes it a little bit more interesting for you. Anytime you talk to an attorney, you always need an extra cup of coffee because it can be dry and boring. I am a tax attorney, so it can be extra boring, but I promise you, if you listen to the end, I have a couple of trivia questions, and if you listened carefully to me, you could win a couple Amazon gift cards for $25. So here we go. I only have you for a few short minutes, so I'm going to impart as much wisdom as I can on you. Do remember, if you have a specific legal question, reach out to your attorney or feel free to shoot me an email or give me a call anytime. This stuff is really important. So here we go. What are we going to talk about today? Oh, it doesn't look like the slides are moving. Hold on 1 second. There we go. So what are we going to talk about today, right? It says IRA news, beware, the IRS may be your new biggest beneficiary. Well, that sounds a bit scary, right? That's probably why you signed up for this webinar, to find out, whoa, wait, what do you mean? The government's going to take my retirement account? So here I've got a nice little picture for everybody to look at that says the Secure Act, a Retirement Enhancement Act. And we're going to go through this a little bit more in detail. We're going to focus a little bit on what an IRA is, what required minimum distributions are, what happens when someone passes away, and how the Secure Act, whether or not it's this act or something in the future, is going to change the way your retirement account works. And I'm going to give you a couple of nuggets of information, a couple of pieces of gold that you're going to want to take with you when you leave this webinar. So the Secure Act, basically what it is it's a retirement act meant to help more Americans save for retirement, right? But in doing so, there's some consequences to it. And we're going to flip back to this picture because I want to talk to you first about what a retirement account is before we really get into what the Secure Act, so we can understand a little bit better the ramifications of where this act is, where it's going, and how it affects you. So let's move forward. So what is an IRA, right? What's a retirement account? We all have them, although in a few slides, we're going to see that not all Americans actually do save for retirement, but probably most of the people on this telephone call, whether you're my clients, you're just a client of the firm, you're a family member or a friend, we likely have these retirement accounts. So we really care about negative consequences. Because in estate administrations, I do estates as small as a couple $1 million to as large as hundreds of millions of dollars. And some of the largest assets in all of my estates are retirement accounts. So it's really important to understand what they are, how they work, what happens when you pass away, and what the law could be changing in relation to that, right? So we're going to start with an IRA. It's an individual retirement account. right? An owner makes a contribution with money and it's deductible on your tax return. The earnings then grow tax deferred until you withdraw it, which is hopefully in retirement. You can take money out of your IRA early. An early withdrawal is before 59.5, and if that does happen, there is a 10% penalty. Remember, the rules are a little bit different between a IRA, traditional IRA, and a Roth IRA. So a Roth IRA doesn't have the same advantages of a traditional IRA. A traditional IRA, it's a tax-deferred savings vehicle, and it reduces your taxable income when the contribution is made. A Roth IRA comes out post-tax. So what you do is if I get a paycheck, I take some of the money before tax comes out of it and put it in a retirement account. That's traditional. Or I can wait till I get that money, pay taxes on that money, and put it into an account. In a Roth IRA, some of the things are going to be a little bit different, but once you pass away, or let's say if you're listening for an elderly parent or want to understand what's going to happen for you as a beneficiary of an estate, it's important to know what happens when someone passes away. For a Roth IRA, there aren't required minimum distributions during your lifetime, but there are required minimum distributions when someone inherits that asset, right? So when you take money out of a Roth IRA, you don't necessarily have to pay income tax in most circumstances. For a traditional IRA, you do. But when someone passes away, whether it's a Roth IRA or a traditional IRA, the beneficiary is going to have to start taking required minimum distributions. And that's the next thing we're going to talk about. So, okay, we've got a retirement account. It's either traditional or it's a Roth. We get to put money into it and we get some kind of a tax savings, whether it's going in or coming out. Then we get to these required minimum distributions. I don't know if I have young people listening in, if I have older people listening in, or something in between. But I am not 70 and a half. I hope you guys can see that with this webinar. I'm very, very young, right? But I'm not taking required minimum distributions. They are required to be taken for traditional IRAs after you turn 70 and a half. And then if you don't take those required minimum distributions, you can actually pay a 50% penalty tax on the difference. So it's really important if you're getting close to that retirement age to circle back with your financial planner, the financial institutions, and make sure that you are taking or are aware what those required minimum distributions will be. I do on this slideshow, and we'll put it up on Cohen Seglias's website. I can also email it to you, but this video and the slides will be available on the website so that you can go back, and if you heard something really interesting, re-listen to it, or you can get some information off these slides. But what I've got on the bottom of this slide is a required minimum distribution worksheet. A great thing to go on, whether you're close to 70 and a half or not, you type in how much is in your retirement account, you look up your age, and you can simply calculate an estimate of what those required minimum distributions would be. So now that we know a little bit about our retirement accounts, right? Our 401k, our 403b, our SEP IRA, our Roth IRA, what happens after we retire? Well, now we know we've got to take those required minimum distributions for traditional, not for our Roth IRAs. But now what happens after we pass away? Well, first we need to figure out who's the beneficiary of my retirement account. So as an estate planning attorney, I want to see all of my clients' assets because assets transfer in lots of different ways, and a lot of people don't realize that. They come in, they do a last will and testament, they say I want everything to go to my spouse, and then they have an IRA beneficiary of their sibling because they put it on before they got married. Those assets actually go different ways. Even though the will says everything goes to my spouse, that retirement account with my sibling as the beneficiary is actually going to go to my sibling. There's also issues with jointly held property, business interests. So it's really important for each sector of asset that you have to really understand where that goes when you pass away and what the ramifications of it are. So normally if you have a retirement account and you're married, it's first going to go to a spouse. A spouse has a little bit different rules than everybody else, a little bit better. We're going to talk about the Secure Act, but part of the reason that we have this type of retirement plans here in the United States is we're getting some kind of a benefit because the government wants us to save money for our retirement. Now, are they doing that out of the kindness of their own hearts? I would like to think they are, but it's really because they don't want to pay for our retirement, right? They want us to save money so we can take care of ourselves. So they offer some wonderful tax benefits to ourselves and our spouses. Unfortunately, in 2015, there was a Supreme Court case called the Clark case that actually took away all creditor protection for any inherited IRAs. So post 2015, a lot of estate planning attorneys like myself, once we get retirement accounts at a certain wealth level, we're going to move those assets out of individual names and into trust names. But remember, the trust has to be a very special kind of a trust. So I wouldn't print something out on the internet and change the beneficiary designation without talking to an attorney. But for a spouse has a couple of options when someone passes away. They can either roll it into their own IRA and either continue taking required minimum distributions based on their life expectancy, or if they're not at retirement age, keep it in there and grow until they're required to take required minimum distributions. Or they can create a separate inherited IRA and use the life expectancy of either themselves or their spouse, depending on who is older, which tax is better for them. It's how they're going to do it. Unfortunately, all other beneficiaries don't have that option of rolling it into another IRA. They're going to get an inherited IRA. And no matter how old they are going to have to take required minimum distributions on that account. That's really important to remember. Whether it's a traditional IRA, a Roth IRA, no matter what, we're going to have to take required minimum distributions. So my grandfather passed away. He left me some money in an IRA. I'm only 36 years old, but I have to take required minimum distributions, but I get to take them at my life expectancy and not my grandfather's life expectancy. That's really important because I have to take out far less and more can stay in that account and grow tax deferred. Whereas my grandfather, because he was 96, had to take pretty large distributions from that required minimum distribution calculation. And remember, I showed you that link to sort of figure that out. So that's really what's known as the stretch, which is an incredible savings that has been bestowed on these retirement accounts from the government, but they're always trying to take away because it either wasn't taxed or it was taxed, but it's not being taxed on the way back in for a long, long time. So they're always thinking, how are there ways that we can get rid of that stretch? Because that's very beneficial to families. To me as a beneficiary, I get a lot of benefit. I actually get a lot more money in the end because of those stretch provisions. So now you will say, okay, wait, you said there's some IRA news, there's something going on, the government might be my biggest beneficiary of my retirement account. We're now talking a little bit about retirement accounts. We're talking about required minimum distributions, and we understand a little bit about what happens when somebody passes away, so we can better understand the ramifications of the Secure Act. So that's what we're talking about right now. I think this slide is covering it up just a little bit, but it's Community Up for Retirement Enhancement. So it's all it is we want more Americans to save for retirement, which sounds great. In the House of Representatives in May of this year, it almost got unanimous approval, 417 yeses and 3 noes. But as of late November, the last time I checked in just a few short days ago, the bill is stalled in the Senate. There are 3 holdouts in order for it to get unanimous consent. If it gets that unanimous consent, it will become law in 2020. I'm a little on the fence whether or not that's going to happen. We only have a few short weeks until we get to the end of the year. I think they might actually try to, if they can't get those 3 holdouts to sign on, they might try to push it into a broader bill that has to be passed by the end of 2020. But it doesn't matter whether the Secure Act is dead in the water or not. It's important for us to understand our retirement accounts, how we have to take required minimum distributions, what happens for ourselves and our family members when we pass away. Probably the biggest takeaway that you guys are going to get from this 30-minute webinar is go back, check your beneficiary designations, and make sure they say what you want them to say. I have done thousands of estate administrations over the decade that I've been practicing, and it is one of the biggest mess-ups that family members make. So if you're a client of mine, I'd like to say that will never be the case because I make sure that's not the case. But what you need to do is make sure you've got the right beneficiaries in place. If you don't have a beneficiary, that asset is going to fall to your estate and be guided either through your will or through the intestate code of Pennsylvania. Of course, if you're in a different state, listening through that state's intestate code. And that's really important. It sounds like, well, that's fine. It doesn't really matter. Except if that's the case, then the beneficiary can't actually take required minimum distributions because an estate or the intestate code doesn't have a life in being, which just means all of the income for the entire retirement account will be due up front and once. That's catastrophic. And again, remember, in my estate administrations, IRAs, retirement accounts, can be the largest asset, right? So it's really important to make sure those beneficiaries are in place. Again, even if you update your will and have it say everything that you want to, if you don't go back to change or update those beneficiary designations, things are not going to work in the right way. So the takeaways, I'm going to talk to you just a little bit about the Secure Act. There's 29 provisions in it. A lot of it we don't have to worry about. If this bill's dead in the water, there's not a whole lot of takeaways you need, although great conversation pieces for over the holidays, that you know a little bit about how a bill gets passed, that there's something sitting on the Senate floor, and a little bit about that bill, right? But it is important for us moving forward because the government, the legislators are always trying to figure out ways to remove or limit that stretch. And we who have retirement accounts, and me as an estate attorney, is always trying to figure out ways to get you the biggest benefit for the retirement account that you have, give the most savings that we possibly can to you, and avoid as much tax as we possibly can. So these key takeaways, you can read them, but basically, we've set up a system so that it's easier for small business owners to set up these retirement plans. We're allowing annuity companies to come in to reduce the liability of these insurers if they can't meet their obligations. So just adding a little bit more flexibility of what an employer can do. Also adding in some provisions so that a part-time employee can actually be part of this retirement plan. One of the things that's really great, and it would be a shame if it doesn't pass for this, although we really, I think, don't want it to pass because of the stretch provisions, is they've pushed back in this bill the age at which is retirement, which right now you have to start taking required minimum distributions. So you have to take money out of this tax deferred vehicle, which you don't want to do unless you don't have any money anywhere else. You want it to stay in there and grow tax free, take advantage of that tax deferral. So they're talking about moving it from 70.5 to 72. I can say that scares me a little bit. That's more of a benefit. It means more can stay in tax deferred. But my thought is, why are they doing that? And we're going to actually see on the next slide why this act even came into being. We won't spend too long on it because, again, I think everybody who's on this phone call is probably saving for retirement, do have retirement accounts with a considerable amount of money in them. But it's interesting that they did this because I think people aren't saving for retirement and they are working longer. So that terrifies me a little bit because as much as I love my job, someday I would like to retire. And if they're thinking people are still going to be working in their mid 70s, I'd actually like that number to go down a little bit, right? And maybe you guys would all too. So of course, there's another provision that allows a little bit of 529 accounts, a little bit of tax advantage 529 accounts for the repayment of student loans. We all know student loans are a bear. I've got a lot, if you can see behind me. I've gone to college, I've gone to law school, I've gotten a master's degree, I've gotten an estate planning certificate. Each of those things has made me better prepared to help my clients, but it also has cost something, right? So we know those student loans are there for a lot of people in this world, and anything that the government can do to help us repay them with other funds or in a tax advantage way is helpful, right? But the biggest concern, and that's why I've said that the IRS may be your new biggest beneficiary. And if we go back real quick, let me see if I can go back to that picture. The reason that this picture is here is the last key factor, which is it's going to limit the stretch of your retirement account for your beneficiaries from their whole lifetime, which it currently is. The IRA that I have from my grandfather, I can stretch out over my whole lifetime, which just means it can grow more tax deferred, which means in the end, I or my children will get more money. By limiting the stretch, it will mean that you have to take the money out and pay income tax on it sooner, which is why we've got the chickens going back into the hen house with their golden eggs, right? Which is the retirement savings. Uncle Sam is posting a note on the door. He's the fox in the hen house, right? He's taking that money before he should be, because when we signed up for these retirement accounts, it said we could defer it over our whole lifetimes for our beneficiaries. Now we're taking that away, a little bit like the fox in the hen house. And annuity companies, they're just sitting by the side and thinking, oh, this is great. I don't really care about any of these other provisions, but now it's easier for me to be included in retirement plans. So let's get back here to the key takeaways. So what we really care about is that limiting the inherited stretch to 10 years for non-spouse beneficiaries. So why is this bill even in place? We all have retirement accounts. It already said we have a stretch for our beneficiaries' whole lifetime. Why are they messing with that? Well, what's so scary is most adults don't save for retirement. Not probably the people I'm on the phone with, not many of my clients, but a lot of Americans don't save for retirement. So they're trying to think of a way to help Americans save more. Even Vanguard, we all know Vanguard, the wealth management giant, right? In 2019, the median 401k balance for people 65 and older is $58,000. Slightly terrifying to me, because part of what I do is help people prepare for retirement. And if you only have $58,000 saved for your retirement and you're older than 65, that's going to be a really scary situation. So the Secure Act, it was to help employers sort of offer these plans. It's just this little tiny provision got added on that won't help you and me who are already saving for our retirement and for our family's future. That should not be in there. So we'll sort of look at this picture. It just says, you know, does this act help people save? Or is it really just taking money from the rest of us who have saved and affecting our families, affecting our retirement accounts that we want to pass on for future generations? Remember, in the estate world, your retirement account is one of your biggest assets, right? So it's really important to understand the ramifications of what happens. And I'm going to give you another little nugget right now, which is, one, I've told you, make sure you go back and check your beneficiary designations of your retirement account. Critically important. Another takeaway is, be careful putting beneficiary designations on all your assets. Sometimes ne'er-do-well financial planners or even banks and financial institutions say, oh, just put a beneficiary on that and you'll avoid probate. Oftentimes that's not what you want to do, and people don't understand what the probate process is. I'll have a webinar in the future about what a probate actually involves, but a quick synopsis is when someone passes away, there's a probate process in Pennsylvania. Anything that has a retirement asset is not part of it, but it's still actually subject to inheritance and federal estate tax. So it's not really saving any tax to have that beneficiary designation, and probate in Pennsylvania is pretty inexpensive and can be opted out of. But for a retirement account, we have to be very careful who the beneficiary is so that we make sure we continue to get this stretch and that we get all the tax advantages that we should with this retirement account, and we don't end up cutting off the foot of, let's say, one of our children. So we're getting to almost the end of this video webinar, and if you're still awake and you're still listening, I've got a couple of trivia questions for you. So how this is going to work is I'm going to pull the slide up. I'm going to ask you the question, and the first person to respond in this toggle, I don't know what it's called, on the side, but this bar that you see on the side where you can ask questions, you're going to type in the right answer. The first person to get the right answer will get an Amazon gift card for $25. Is everybody ready? Do you have your fingers ready to type quickly? Great. You might have learned a little bit from this in this lecture. If not, give a guess, but it's really important to know these answers. So the trivia question is, so Brian has left everything in his last will and testament to his only child, Patience, but he still has a beneficiary designation of his old girlfriend, Whitney, which is his largest asset. Who inherits the IRA? Is it Patience or is it Whitney? I don't know quite how I see that on the side, but let me see if I can see if somebody's gotten to the right answer. Great. Yeah, we've got a lot of answers. Awesome, guys. There's a few people listening. This is great. When it comes to a gift card, you guys all woke up, right? So who inherits the IRA? It's Whitney, right? Do you think that's where Brian wanted his retirement account to go? What if that's the only asset in his estate? It's all gone to his ex-girlfriend and not to his child. So again, this is the major takeaway from today is go back, look at the beneficiary designations on your retirement account. Make sure they say what you want them to say. And if you're not sure what they should say, reach out to an estate planning attorney and say, I listened to this webinar, something about retirement accounts and the Secure Act. Is there something that I should be doing with my retirement account to keep it better protected, to make sure that my children do inherit this stretch as long as the Secure Act doesn't go through? And you should be in great shape. A funny story, I started at this firm, I guess it's been about 1.5 years now that I've been at Cohen Seglias. And when I came here, I got a retirement account, right, a 401k. So that same advice that I'm giving to you, I'd given to myself. I filled out all the paperwork, I turned everything in, and about a month later, and this is what I tell my clients to do, double check, get confirmation that these are the beneficiary designations. Well, I never got that confirmation, reached back out to our HR, and it had actually not been inputted in the system. So for about a month, I could have had a catastrophic event with a retirement account if I had passed away. So it's something that could happen to absolutely anybody, even an estate attorney who knows how important these things are. So it is worth taking a few minutes to go back and check those retirement beneficiary designations. So now we're going to get to the last and final trivia question. I think I'm almost out of time here, which is perfect. One last trivia question for another Amazon gift card for $25. Christmas is coming up, and there are things that your family may be requesting. My son asked for an adult electric scooter last night, which I looked up on Amazon is a few $1,000s. So we're gonna look into a child version. But if I was winning this, I'd have $25 towards it. Okay, here we go. So the next scenario, right? We've got Brian. He's got his last will and testament, which everybody should have. And there's a tax clause that says my residue will pay the tax. out of all of my assets, the residue will pay the tax. Now, we could have many, many more webinars on what that tax is, but if you're a Pennsylvania resident, when you pass away, anything that passes to anyone else is subject to a state death tax and a federal death tax. So keep posted. We'll send out things in the future, and I can talk to you more about those taxes and how to reduce or eliminate those taxes, but they're there. So who pays it in this situation? Is it the estate, patients, or is it the IRA beneficiary? Remember, that ex-girlfriend got that IRA. Let's say it was worth $1 million. Who pays in Pennsylvania if she's an ex-girlfriend? She's taxed at a 15%. Who pays that 15% tax? And I'm just looking to the side, see if anybody's got the right answer. A bunch of people have responded. Awesome, you guys are great. Some of you got the right answer and some of you have not got the right answer, but it's the estate. So I have had many estate litigation matters where this actual scenario has happened. And I hope, because you've listened to this webinar, it won't be anyone on this call. But yes, if you have a will that says my residue will pay all tax, it's going to pay the tax on that IRA, and the difference will go to patients. So in reality, it means patients is going to pay a tax on an asset that she didn't get. So this is why it's so important to understand a little bit about what a retirement account is, how those required minimum distribution works, what happens when somebody passes away, what is this stretch thing, what are my beneficiaries, and what is the government trying to do to eliminate some of the benefits there are, and what am I doing to make sure that I have the most benefit out of my retirement account humanly possible. Well, it looks like it's 12:30. Thank you all for listening to me. I really appreciate it. Certainly give me your feedback on what you think about this video webinar. I was impressed, although sort of staring at myself the whole time, which is pretty interesting. But I'd love to hear your feedback. On whether or not this was helpful to you, and we'll do it again, probably not this month, but in January. So I hope to see you in the new year. Again, if you ever have any questions or concerns, please feel free to reach out to me or reach out to your estate attorney if I've unleashed something that you'd like to talk to somebody about. Again, I hope you have a happy holiday, a wonderful winter season, and we'll see you in the new year. Thanks, everybody.